so much for joining us for this talk that we're very excited about. My name is Naz Modir and I am the director of the Harvard Law School program on international law and armed conflict, and I'm very delighted to welcome Dr. Sharon Weill to Harvard Law School and for this really exciting topic. I know that many of us have been increasingly paying attention to what has been happening in Europe in the realm of counterterrorism, criminal law, foreign fighters, and international humanitarian law. And I think we're particularly enthusiastic to hear about your new research. I'll just give a brief biographic background and then hand the floor over to you. Dr. Weill is a senior lecturer in international law and an associate researcher at CERI at Sciences Po in Paris, where she directs a clinical course on counterterrorism. She's an expert member of the French National Commission on Human Rights and vice president of the Committee on International Humanitarian Law, Development and Environment. She is the author of the book, The Role of the National in Applying IHL, and her particular field of interest is the relationship between international and domestic law, the judicial enforcement mechanisms of international law, counterterrorism, and the global war on terror. Her ongoing research projects include a pluridisciplinary research project on counterterrorism trials in France, which we'll be hearing about today, and which is financed by the French Ministry of Justice. We're really delighted to have you.
Okay, thank you so much for having me here. It's a real pleasure to be in Boston in the spring, and and we have snow, so it's wonderful. Okay, so as Naz said, I am going to speak a little bit about, let's say, France's war on terror in its internal front. So, as you know, France joined the coalition in Iraq already in September 2014. And then later on, it was also involved from September 2015 in Syria. So after we have the terror attack in France in November 2015 at the Bataclan, here, of course, this is like the 9/11 in France. And France declared officially its war on terror. So we had the front outside in Syria and Iraq, and we have the internal front in France. So I will be focusing mainly on this internal front, but we have to keep in mind that it is really a part of this general global war in terror, while this war, unlike the US, is fought with French citizens, because the ones that are going to join the groups in Syria or the one that did the attacks in Paris, they are French citizens. So in a way, this is external, internal, and it is, of course, based from an internal society problem that we have in France. And today we will see what are the legal avenues that France has chosen to deal with its own population that decided to join this group. So there is one magistrate, Antoine Garapon, that wrote a very interesting book, and he identified the justice in France now dealing with terrorism as a preemptive justice. So as we all know, we have what, for example, we know as preemptive strike or whatever, the preemptive self-defense that we have outside. And now we can see that inside the borders, we have also the criminal law justice to do the same kind of war of this preemptive justice. So what did France do? France went in two directions. First of all, we had the administrative law. So France declared immediately after the Bataclan terror attack 2 years of state of emergency. So 2 years, it was every time for a few months. It was prolonged 6 times to have 2 years of derogative measure, administrative measure. This is on one side. And the other side, you have a proactive and preventive criminal policy, which is very, very repressive. So I will look at these two avenues to see what happened. But again, we have to remember that when we deal with this, there is always this external link. And I brought one case that was rendered in July, for example, about foreign fighters that came back after fighting in Syria. So you can see in the criminal decision, in the judgment, you have one page that is named Le Contexte Géopolitique. And within, so it's a criminal trial, a national criminal trial, but you have more than almost 2 pages that speaks about the armed group in Syria and where the Khalifa was declared and the bombardment of France in the coalition, and et cetera, until we arrive to the terror attack and the fact that now France are joining these terror groups. So this is about this international background. Now, as for the administrative measures, so in general, we can see that during these 2 years, since the declaration of state emergency until today, also after, we have all the time the expansion of executive power. So executive power means, of course, that it's before doing the act. Because if you have the act, of course, it will go to the criminal avenue. Here is where the authority are imposing limits on liberty in order to prevent people to go to Syria, in order to prevent whatever, to develop terror plans, etc. So we can see the constant expansion of this legislation and the transfer from the judicial judge to the administrative judge. Because when you have an administrative measure, it is done without any judge. It is done directly by the authority, but then it is reviewed by the administrative judge. Now, what is important to understand in France that you have 2 judicial systems. There is the criminal system, which is the judicial judge, the law school, normal judge, etc. And you have the administrative system. In the administrative system, you don't have judges that did law school. They did the School of Administration, l'ENA. It's the National School of Administration, very prestigious, very hard to get in. And people getting out from this school are the people that are going to have the key position in the public position in France. So one of these positions can be to be an administrative judge. So they don't have necessarily any legal background. And the administrative judge, also the way they are designed, and traditionally they are very much close to the government. The Conseil d'État, the upper jurisdiction, is also the state legal advisor. So they are much more close to the government than the regular judicial judge, let's say. So we see that through the expansion of the authority, there is also, in a way, we take the competence of the regular judge to have oversight over liberty towards the judicial judge, which will accept evidence that won't be accepted in normal criminal cases, like les notes blanches. These are like notes from the government, not signed. We don't know who wrote them, and they will be accepted by the administrative judge. So I will just give you 2 stories in order to have an understanding how the law has developed. So the first example is the issue of house arrest. That was the house arrest. So house arrest, it means that you have the power to put a person into a curfew in his house, let's say, or it can be a curfew in the city, or in you are delimiting the place where a person can move, up to impose him a curfew in his home, up to 12 hours. During this time, he can be asked to go 3 times a day to the police station to sign. Voilà. So this authority existed only through the law of state of emergency. So only from 2015 we could exercise this authority. It's origin from a very old law of the Algerian War from 1955, where you had the first state of emergency. So this is a very old law that you had during states of emergency. But of course, it couldn't exist outside the state of emergency, only in a kind of pretrial detention, but this would be through the judicial judge. Here, it's the police or the préfet that will decide on the measure if it has a reason to believe that there are security interests of doing it. So during the state of emergency, you had 700 people that were put under house arrest into different degree, not everybody on the same level. And the peak was at the beginning when you had 400 people under house arrest. And then, of course, you can imagine that these people could not continue to work, have enormous impact of the way of family life, etc. And you have person more than 1 year under this measure. Okay, so this was during the state of emergency, 2015. Then a year later, for the first time, you have the first legislation allowing house arrest outside the state of emergency. So it was just in regular law. And this was the law, especially for the returnees. So the one that came back from Syria or other combat front could be put in house arrest during 1 month. So it was limited to 1 month. This was in June 2016. A month later, it was for 3 months. So this was the first legislation that we had outside state of emergency. Another year passed, and when we ended the state of emergency, in parallel, there was introduced a new law, which is called, it's a new chapter under the security law, which is called Individual Measure of Administrative Control and Surveillance. I think that even the name, it's really, I mean, we have so much individual measure of administrative control and surveillance. So no one at least, tried to make it with better wording. And one of the measure is house arrest. So now we have this in our regular law. So no need state of emergency, no need derogation, no need to declare anything. We just have it in the regular law. So this is to show how this escalation in legislation, when you start, and then it becomes so rapid, the change of legislation. So what? And today we have about 40 people under house arrest. 40. Now, what about the judicial review that was done about this? So during the state of emergency, the Constitutional Court looked at the legality of the law itself within the state of emergency. And the petitioner, their claim was that this is a limit on the liberty of a person, and only a judicial judge can review limitation of liberty. This is in French Constitution. The basic habeas corpus in France is that only the judicial judge is responsible for to review the liberty of person. This is Article 66 of the Constitution. So the argument was, here it is an administrative measure reviewed by the administrative judge, and therefore it is unconstitutional because only a judicial judge can review measure dealing with liberty. Is this clear, the distinction? So what did the court decide? So what the court said was that this is not a limit on a liberty. This is a limit on freedom of movement, because it's limited only to 12 hours. If it was beyond 12 hours per day, it was an issue of liberty, but it is beyond 12 hours, therefore it's not an issue of liberty, but only of freedom of movement. Well, so I know that it's sometimes hard to understand how to be imprisoned in your own home is not a limit on liberty, but this was the definition of French judges. Then another example of showing again this escalation is a prohibition of leaving a territory. So in 2014, you have an administrative measure of prohibiting an individual from leaving the territory of any French national may be subject to a prohibition of leaving a territory if there are serious grounds for thinking that she or he planning to travel abroad in order to participate in terrorist activity or reach a territory where terrorist groups are operating in condition likely to lead him to be a threat to public safety after their return on French territory. Okay, so it's a measure. It is limited to 6 months, renewable for 2 years. Again, we went to the Constitutional Court. The Constitutional Court say again, this is an appropriate balance on the right of movement and private life and security issue because it is limited to 2 years. Okay, so this was in October 2015, the decision. In July 2016, only a few months later, this 2 years limit was simply removed, and now we don't have a limit on how many times we can impose this, although this was the real reason why the court found it constitutional. So now we still have to see if another case will go. For the meantime, we still didn't have any case reviewing it. So as we can see on the part of the administrative measure that we have a constant evolution of the legislation with the empowerment of the administrative judge. So these were the administrative avenue. Now I will speak a little bit about the criminal avenue, which is the main area of my research, and then after we could have maybe more discussion. So the criminal avenue, let's say about people returning from Syria or Iraq, like the French foreign fighters, or the one that wanted to go or participate in any terror activity on French soils. So although we are here in the criminal part, it's also very much a preemptive justice in a way. So we can see that also in the criminal justice system, as in the administrative one, we are in this system of danger assessment, of profiling people, I mean, you know, so you identified certain behaviors, certain way of belief, certain way of doing, and then you will correspond this to certain categories that you have, and then you will apply your category on the people because you still don't have the acts. So actually we can see that the criminal part become more and more preventive in the way that it intervenes in the very much preparative part. And this is said very openly in France by the investigative judges, by the prosecution. It's not something that is not accepted. It's part of the system and is justified to prevent because a lot of pressure is put on the judges. So a little bit about data. So from 2014, we had around 200 cases rendered so far. You have still 410 persons under ongoing investigation and 270 placed in pre-trial detention. So just to understand that when you have someone returning, he is put immediately in pretrial detention, and his investigation starts by the investigating judge. All the investigation are centralized in Paris. You have the investigation done in Paris and the trial done in Paris. As a pre-trial, you can be up to 3 or 4 years in pre-trial detention, depending if it's a délit or a crime. Délit, it's offense until 10 years of imprisonment, and beyond 10 years of imprisonment is a crime. And then depending on this, you will go to the first instance chamber or to the special court of second instance, the cour d'assises. That there you don't have a jury, you have only judges, professional judges. So what is interesting is that all these cases, the 200 cases, or the one that are now ongoing, almost all of them are on the same incrimination, which is association de malfaiteurs terroristes. The translation in English, I did a real translation, is association of wrongdoer in relation with terrorist enterprise. So it defines as a terrorist act the mere participation in a group in view of the preparation of a terrorist act. And it can include attack on property and life, financial or logistical support, with this special intention of intimidating the population. So in general, what you need in this, why is it, this crime that everybody is prosecuted? Because it is very wide. What you need only to prove is that you joined the group and that the group had a terrorist aim. So you don't need to contribute at all to the act to be done, the terrorist act to be done, and you don't need even any act to be done. It's only the fact that there is a group and the group has a plan to do an act. Okay, so it may resemble to membership in illegal organization, between membership and conspiracy, something in between, I would say. I don't know, Alex, maybe joint criminal enterprise, I'm not sure, but no.
No,
No.
because joint criminal enterprise is not inchoate. You have to have the crime.
Okay, exactly, okay.
So it's closer to conspiracy.
Conspiracy, yeah. So it's conspiracy, but even it...
It's even not conspiracy, as you
Exactly.
describe it, because it's not an agreement to commit a crime.
Exactly. Well, it's you join a group that has an agreement to do something. So you join, but you don't necessarily need yourself to be committed to do this crime itself.
Do you need to know about it?
Yes. Okay, so it's a good question. I mean, you need to know or should have known, huh? Yes. Because we had now recently the prosecution of the case of Mera. So Mera, I don't know if you've heard about this, probably yes. In 2012, it was the first jihad or terror attack linked to jihadism in France, that you had this person that was, he was killing French military and Jewish kids. Okay, so it was a big terror attack in France. He died when he was arrested. And we had now the trial 5 years after the fact. So we had the trial, his brother, okay, and whether or not he was involved in this, and the person that sold him the weapon. So the person that sold him the weapon, okay, he was not a nice guy, but he was from the neighborhood. He's a weapon trafficker. And he said, listen, I sold him the weapon because he told me that he's going to do robbery, a braquage. I have no idea that he's going to do, of course, he's not telling me, no one knew about it. I mean, the security services didn't know about this, so why the person that sold him the weapon? And even in the indictment, it is written by the investigative judge is saying, it is not excluded that he thought that it would be for a robbery. But then the prosecution was saying, they are friends from childhood. They are from the same neighborhood. It's not possible that he was not aware of his radicalization process and of the potential of doing a terror attack. And he was accused of this. Yeah, so it's very, very far in this sense. But anyway, you should prove the knowledge. Okay, so as you can see, the association de malfaiteurs is it has a very broad scope. It's very easy to put people to accuse them. Very little evidence are required. And I mean, this is not a new offense. In France, you have it from always, let's say. Now, what is new, however, is that always it was a very large net, and you have a low level of punishment, because, you know, if you really did something, you will be accused of the act, right? And now what changed was the prosecution policy, that now everybody that went to join Syria after 2015 will accuse of association de malfaiteurs as a crime, and he can be and he can have 20 years of imprisonment. And in 2016, the legislation changed to have 30 years of imprisonment and life imprisonment for the leaders. So you see how broad it is. So I will read you an indictment of a case that was last week. This is the first case that we have following this prosecution policy, because all the 200 cases that I told you that we have so far, they were of people going in 2012, 2013, 15. It takes 3 years to have the investigation, 2 to 3 years, you know. So, and now this is the first indictment of this new. So people were getting like 6 to 9 years imprisonment if they fought there. They got 2 to 4 years if they attempted to go. The recruiter a little bit more. This was the level of punishment, and now it will go up to 20. So I will read you just the indictment, so you will see. The terrorist nature of the two jihadist groups, Al-Nusra Front and ISIL, that commit criminal acts, such as suicide bombings, assassination, and other summary executions, with the aim of disturbing public order through intimidation and terror, for the purpose of instituting an Islamic State, cannot be disputed and could not be ignored by the accused person who shared the same radical and pro-jihadist convictions. Integration in such a terror group, followed by religious indoctrination, military training, and participation in criminal activity of this group, in this case, at least combat, you see how combat is a criminal activity, constitute, without us knowing if they did war crime, of course, constitute association with criminal terrorist wrongdoer with intention of committing crime of injury to person. All that must be demonstrated is that the accused had the knowledge of the criminal nature of the offense prepared by the group. The association does not have to be linked to the preparation of a specific act of terrorism. And then in the same indictment, it was even precise that it cannot be established that the accused has any intention to do any violent act in France. So you see, it's all about the extraterritorialization of this crime that, by the way, I forgot to say, in 2012, it became extraterritorial. So, of course, now what can we say about this? So 3 points, and here we can discuss about this. First of all, the problem is that we are not really looking what these people are doing. Because, for example, in this case, perhaps they torture, perhaps they rape people. Who knows what they did there? We are not looking at all of what they are doing. Just they joined them, they have military training, it's enough. And they got 14 years here. So we don't have this scale of action. Everybody has the same accusation, no matter what acts they committed. And this you can also see that you don't have the war crime investigator and prosecution office investigating the cases. It's only the terrorism cases. So in this way, we are not really interested to render any justice to the victims there. We're just thinking about protecting the French from future terror acts. So of course, there is a slight problematic here. And also, if we think about the rehabilitation of people once they are in prison, it's not the same if you commit a torture or a rape, or if you just were lost, you smoked some joints, you decided to go to fight there to get excited, and you were afraid and you came back. Because you have many people that this is also their case. They are not all so much ideology. But when you don't do this differentiation, and they're all under the same umbrella, so it have a lot of problem in this sense of thinking what will happen to this person in prison and after going out of prison. Because now the intention of France, so you have a social problem, you look at all these people and you simply put them in prison. But what happened to these people? They go out of prison, they will not be able to work in many, you have a list of professions that you can never have, you cannot do this, you cannot do that. Today, being under a terror conviction is a very, I mean, it's hard to continue the life after. And I think that in this sense, a better work should be done because we can see that not all the cases are the same. Now, I don't know if I speak about the trial themselves, or maybe another something that we should think of is about the person that are currently in Iraq and Syria, the ones that are now in prison there. So the official position of the French government is that they are not going to ask the repatriation. It can be done case by case. So of course the question in Syria, who may be the one prosecuting them? So we have people that are held by the Kurds in the north of Syria, in the detention camp there. You have detention camps of women and children. They are there. What is going to happen to this person? We don't know. In Iraq, there are foreign fighters there. We know that there is no fair trial there. People are being tortured. There is death penalty. And France is refusing to take them, to prosecute them there. So this is another category or group of people that we have. So this is, in general, to show you what the avenue that were taken by France. Now, I don't know if you want to open some discussion. Otherwise, I can speak a little bit more about the trial themselves that are very different from the common law system. It's a civil law system. So I don't know, maybe, yeah, exactly.
About the trial, and then we'll open up.
Okay. So the trial. So as I told you, in France, from the moment the person is arrested and we start the investigation, so it's already done by a judge, okay? So in a way, you can say that the trial, in a way, already started there. But of course, it's not open. It's a secret investigation. It is adversarial, so they have a lawyer. And it can take up to 3 or 4 years, and then you can wait another year for the trial. So it's very long. This is why today we are reviewing facts of 2014. Yeah, it's a long way. As I said, they are all in pre-trial detention, some of them in isolation. We don't have any data on the isolation. And then they arrive to the trial. So I want to speak especially at the trial at second instance. These are the trials that I'm mainly watching, and those are the trials that are going now to be there because of the policy of imposing 20 years. So there is the principle of oralité des débats. So you have a judge, and here you don't have a jury. It's only professional judge. So you have one presiding judge plus 4 magistrates. They can be different judges. They can be family judge, investigative judge, whatever. You just bring them for this trial. So they are not specialized at all in terrorism. They come here. They are unified for this trial. And the principle is oralité de débat. Everything should be in oral. So only the presiding judge has the file of investigation of 3 years, 4 years of work. Only the presiding judge can read it. And every single fact that we want to take into account should be presented orally. So it takes very long time. This is about the fact. And the trial starts by what we call l'enquête de personnalité. So the translation is investigation of personality. So the idea that you take 1 day, sometimes 2 days, to understand the person, to look at its path. So you will start with school to see how were his grades, if he had problem with school. After, what did he do? Did he want to do some professional formation? Did he work? What happened? Did he quit? Why? When did he get converted? Does he come from a Muslim family? When he started to get interested in religion? Is he married? Is it a religious marriage, not religious? What mosque does he goes? All these questions from childhood until today to understand this. So at first, the person will talk. Then the parents are coming to give testimonies. Sometimes the boss, sometimes the neighbor. Depends what are the testimonies. So you have an entire 2 days. You have the psychologist. So in a way, there is a real attempt to put this person in its environment and to understand his act beyond, like, I know that in common law it's not understandable, because here it will be always what is the fact, in this time what did he do, and this is it. Everything else will be impartiality. But here is really the contrary. You really put this person in the context. And in order to understand his path. So what is been very interesting, for example, I saw a trial with 20 accused persons. The Counterterrorism, it was the first terror trial. It's not, there were only 2 that came from Syria. Many were acting on French soil. And then all these stories come to emerge, you know, and you have people coming from Buddhist family, from Jewish family, from Christian, just without any people that were looking. They first try some raga, some humanitarian work, and then they become radical. So, you know, you have different paths, different stories. And what was really interesting is that here, in this tribunal, you have the opportunity to hear the story from the persons, to meet the family, to see how, if now in France we have a social problem, and there is, because there is this violence that comes from the French that are in France, then you start to understand. And in this way, I think it was very interesting to have this trial that you hear the people speaking. And after so many days, it was a trial of 55 days, so in a way there is the expectation that at one moment the truth will emerge. Okay, whether it works or not, this is another question. But at least this is how the narrative is created in France. And in this trial, for example, at the end of the trial, you have one of the accused was saying, "Thank you for listening to us so long," because some of the accused are simply not used. The authority, the judges, the people, you know, from another world will take so much attention to them. So, of course, now the answer that we have is repression, is a lot of punishment. But I think that we could have also those trials to put another view on those trials and to try to better understand what happened to the people and to try better integrate them back to the society where possible, instead of having such a repressive approach. And we can see that the judge, some of the cases also go in this direction, especially in the court of second instance. And they don't always follow the request of the prosecution. So this is to see what will happen, because it's only the first cases there. But in the first instance, it's less this situation. But this is what I found really interesting in this experience in French courts, when you can really hear the people's path.
Fantastic. Thank you so much. I think we will take, if it's okay with you, I'll take a round of questions and comments and then come back to you. And we'll open up the floor. Yes, Professor Weill.
So I have a couple of questions. The first is, with respect to on the criminal side, you question, well, you pointed out that it isn't proof about what they did, it's more the focus is on the risk that they pose to the future. Now, of course, one challenge in proving what they did is, if it's extraterritorial, is getting the required proof. Are the rules the same in these cases for proof that is required for what they did, or are the rules of evidence relaxed in any way to, allow more either greater hearsay, for example, or is there any allowance for any, intelligence information, any secret information, right? And then on the second thing, I take it on the point of orality and hearing from the accused that focus on their background and personality. Here in the U.S., the concern is that focus is prejudicial to the defendant. But the point I'm hearing you make is that it's the opposite, that it's actually beneficial for the defendant. Does it play out that way? And then what if the defendant refuses to cooperate, doesn't speak?
Okay. Yeah. So about your first question, again, it seems that your question is a bit common law question, because in the civil law, the rule of evidence, it's not at all so procedural as in the common law. And this is because you have the investigative judge. So in a way, the investigative judge, he will assess the evidence, whether it is acceptable or not. It's very rare that you will have a lawyer saying, no, this is not unacceptable. But of course, you will have information of Secret Service, of foreign Secret Service, this exchange of information. Yeah, of course. You will have phones, internet. The thing is that you don't need now that much proof. So it's enough to say you have a ticket, you fly there, you had the person in contact, you have some telephone exchange, we know who was the person who took you there. Basically, it's enough. Sometimes when people are so, okay, we will know more if there are videos, or if there is information, if we see, but basically it's enough.
Is the defendant entitled to see all the evidence against him?
Yes, of course. And also, again, it's a lot based also on his telling. I mean, there's a lot of the assumption is that the accused person is not, that he is talking, he will explain also. So if he is not participating in this, it's not very well, it's not very good for him, because the assumption, of course you have the right to be silent, but the assumption is that during the trial, the accused is the principal actor of his trial, actually.
So it can be held against you that you don't participate?
I mean, it's probably not an evidence, yes, but you should better collaborate, let's say. Yeah. At least from what I've seen, I've never seen person not answering a question. Yeah. But again, perhaps I didn't see all the trial. That is from what I've seen. And also, it's not through the lawyers, it's the person that asks directly. And even if, for example, you are the judge, you are questioning the accused, then I'm a co-accused, I can raise my hand and say, I wanted to add this. Or, it's kind of, it's less strict that you will have in the common law. And, so I answer your question.
So one question I have concerns the different nature of the crimes here. So you mentioned war crimes are much more rarely prosecuted, and this association crime is very commonly prosecuted. I'm wondering what you think the main stakes are in terms of the risk that the French population is willing to face versus the harm in relation to the populations where the war crimes were committed. So it seems obvious that the French population is saying we want to get these people off the streets, they no longer represent a threat. But as you mentioned, there's very little then being entered into evidence and adjudicated in relation to war crimes that might also have been committed, and that might also be much more serious offenses to the international community in some way. So I'm worried that there's a concern that there could be a short-circuiting of a more harmful set of conduct, and how the French courts might be addressing this or how they should be addressing it.
Yeah, it's a very good question and position. I mean, I completely share your viewpoint. Now, you know, it starts at the investigation phase. So it means that you have an investigation unit for war crimes and crimes against humanity, and you have a counterterrorism investigation unit. You don't have the same manpower, you don't have the same budget, so everything starts even there, you know. Yes, more for counterterrorism, and even it became now, even in a kind at the expense, because when you even have cases that you will say, this is war crime, for sure, no, it will go to counterterrorism or financial crime, you know. Like you have the case of Lafarge. It was a French company that continued to have its industry in Syria in the ISIS under ISIS control, and they were paying and they were buying from them. Okay, so you could say they accomplished to war crime. No, they were financing terrorism, and you know, so it didn't go to the war crime unit. And you can see also the frustration of the investigating judge in the war crime unit in a way. Now, why? Again, it's easier. I mean, I spoke with them. They tell me, why should we? I mean, if we are doing now war crime, we need to go to there. We need, you know, I mean, in the rule of procedure in France, you need to go in place. You need to look at evidence. First of all, it's mission impossible now, even if they wanted. And it will take years to do it. And here you have this, you have more level of punishment. And of course, the only concern that also they had is the question of the victim, because the victim has a very important place in French trial. They are party to the trial as civil parties. So I think that in this sense, this is, they are attuned to the issue of the victims, but practically, as Alex said before, it's too complicated to have this fact. So now we know that there's this UN mechanism that is headed by a French judges that sits in Geneva, and the idea is that they collect evidence, exactly what is difficult normally, to collect these evidences and to try national prosecution, to help national prosecution to try war crimes that are related to these conflict zones. So it will be, we have to see if France will be interested in this kind of perhaps cooperation to prosecute for war crimes, or they keep their counterterrorism. Yeah. Yeah.
Two questions. One is, I'm wondering the extent to which, if at all, the countering violent extremism discourse or academic research is feeding into this. So are you seeing references to the radicalization cycle, kind of this new vocabulary that is appearing in this well-funded and quickly spreading new discipline, I suppose? And the second question is, what will happen when this goes to the European Court of Human Rights, if it does? I mean, is this, if this is going from state of emergency into the regular law, it seems like there might be some dilemmas here for France in the future.
Yeah, absolutely. So for your first question, so yes, so you can see, I don't know if it's from outside discourse, but in a way it's the discourse that has been created by the court, you know. So for example, that it always will explain all the conflict that you have between the different groups in Syria, and then it will have always the same question that it will ask in order to identify whether it is radicalized or not, right? So I mean, you know, all these questions. Now, in this trial that I was talking about, that was a big trial, one of the first one, they invited an expert, a sociologue, to give a background of radicalism, which is not this kind of literature that you are referring to. It's a person that Farhad Koshno-Kavari did a lot of research in prison, talking with persons, because of course you need to have empirical research of people that exchange with them and not only in the imagination. So in this way, it was quite interesting to see. And there was also the imam invited to speak, they came to give testimony. And so it's quite an open space in this way, the court. And I didn't feel that they are following a particular, wrong direction, let's say. And you have even the head of the security services that they would come in the Mera. So it's quite a stage where you have really different opinion going on there. But at the end of the day, it doesn't really matter in the sense that you have a kind of a prosecution policy that is decided, and you have a level of punishment that is very repressive, and the margin of the judges is not that big. Although we could see that there is some acquittals, and they are giving less than they are asked for at the second instance, I'm speaking. But, then it can be backed up by the government, by directive, by this, by that. So but I didn't find strange discourse in court, in my view. It was more about, okay, you are part of this group, and you will get 20 years, or you did this, and it's more about this. And the second question, yes, of course, the Court of Human Rights will have a lot of work, but we have to see, it takes time. Yeah, the question of how long you have to wait justice. I mean, you can wait 5 years today to have your trial. 4 years. The question of the note blanche that, as I was saying, is the evidence that are in administrative court. I don't know if it will be accepted in the European level. All this new legislation, now they were all approved by the Constitutional Court in France, so the next stage is to go to Strasbourg. I don't know about ongoing work of lawyer, but probably there is, yeah. Yeah.
I also had plenty of questions, but focus on one or two. The administrative measures, so the way I understand it now, it's getting easier and easier to get convicted for something related to terrorism, right? So what's the profile of these guys in house arrest, for example? I mean, how the French authorities choose to put them on house arrest rather than judge them, for example. And it may sound a silly question, but I've never understood why do we put people on house arrest? How is that efficient at all? What's the rationale for this? I mean, if these guys really want to commit a terrorist attack in France, is there any study on the efficiency of that at all?
Okay, so let me first, your first question. So administrative and criminal, the distinction, if you have evidence, he will go to a criminal trial. Yeah, I mean, you choose the administrative when you don't have. Now, what happened that you have another way of circulation, because if you didn't go one day to sign in the police, you can go now to the criminal and be prosecuted. So sometimes you can go from the administrative to the system of criminal. About your second question, you can have electronic bracelets. You can, if you want to do a terror attack when you're in house arrest, it's more complicated because it's a measure of surveillance that is extreme, so the efficiency, I don't know, but of course it gives a lot of limit on your liberty, now on your freedom of doing anything. So of course also this, imagine. But of course, if we again think about the broader picture, people lose their job. They can't take care of their families. So you put them in a place even more harder. So if we think about reinsertion of the person, you lose them completely. And if they were not radicalized, believe me that after being a year or more than a year in a house arrest, you become, And so, of course, I totally agree that this repressive approach, now, in a way, perhaps one could understand after you have big terror attack, okay, so like a few months until you understand what is going on. But now it's already a long time. And now the front in Syria is over. So, perhaps it will be the time also to start to reassess this repressive, because it's like being a parent. It's not necessarily giving authority and punishment that will raise you better children, right? And I really see it in this way in France, because it's a very paternalistic way of looking at these French citizens. So think about being not so authoritarian and punitive. This is my view, and I agree with you on this, yeah.
And last question, how often are these decisions of house arrest reviewed? Every, 6 months?
Yeah, so, okay, so this is a good, I forgot to, so they are not reviewed. For example, you give you can give it, I don't remember under the new law if it's for 3 months or 6 months, but it's a limit, and then you can renew it. But then people can go to ask judicial review of the administrative judge. But of course, when you had 700 people in house arrest, not many of them went, or even when it's they take your passport, so you can't, because today you have 500 confiscation of passports, so it's more this than house arrest. But people first don't know exactly what to do. They're afraid from the authority anyway, so they don't want to make more problem to go to a judge and da-da. So in a way, yes, you can ask a judge to review it, but in real life, it doesn't happen. It's also centralized in Paris for the confiscation of passports. So if you were confiscated in the south, you don't necessarily have even the money and the energy to come to Paris to see a judge. And so, yeah.
Can you stay a bit to chat with people if they have more questions?
Yeah, we can. Yeah.
Please join me in thanking Dr.